appeal but heard in the matter of Northamber PLC and Genee World Ltd and others.
Yes, Mr. Butler.
My Lords, I will stay within the 15 minutes regardless, but there are two short sweep-up points from yesterday before briefly looking at costs. First is it occurred to us that this court could receive further assistance from a paragraph towards the beginning of the chapter at Clark and Linsell, namely 23-05.
Yes, got that on the desk, yeah.
Which is along the lines of my submission that this court ought not to follow Salvadori and that it's not obvious that the placing of an order without more constitutes inducement. That paragraph explains the state of uncertainty in the law, and of particular relevance is footnote 26. Which is an identification of the tension between, on the one hand, a flexible approach, and on the other hand, the approach which recognises the apparent policy shift in OBG, which is to restrict liability or to confine it within readily identifiable limits.
Well, can I just ask you about that? Because footnote 26, first of all, is pointing out there's a job for the Supreme Court to do, not this court.
Yes.
Secondly, it seems to focus on the unlawful means conspiracy tort, whereas I thought you were focusing on the question of inducing a breach of contracts. That's what Salvador is about.
Well, the editorial before the footnote itself is about economic torts generally, and how the economic torts sit against the wider landscape of tortious liability, which is what I was addressing yesterday. What it comes to, and the reason why this paragraph has been brought along, is that the authority that's cited by Lord Sales, Fish and Fish against Sea Shepherd.
That's about joint tortfeasors.
It is, but it goes on to address the question of accessory liability. Paragraph 21. I've not brought that authority itself. It's an authority that this court could gain some assistance from when retiring. In very brief terms, it was the deliberate ramming of a fishing vessel off the coast of Malta by a vessel owned by a conservation charity, commanded by D3, he being the founder of a charity in the US, D2, and also being a director of a UK company, which was an associated charity to the US organisation. So the claimant, the owner of the fish farm, alleged that all three defendants were liable for trespass to goods. And before the trial judge...
Well, just a minute, before you explain what the case is about, what is the point that you're making?
Well, the point is, at paragraph 21, the Supreme Court say facilitation is not enough for tortious liability in a fairly broad proposition. And that chimes with what I was endeavouring to submit yesterday. So D1, D2 and 3, that's the commonality between them. The first judge at first instance says that D1, which is the UK entity, all it had done is pass on the names of potential volunteers who might engage in this activity to the institution in the US. And the judge said, well, that's of minimal importance. It's got no effect whatsoever on the tortious conduct. Therefore, first defendant should not be joined in. The Court of Appeal reversed that, only then for the Supreme Court to reverse that and restore the decision of the judge at first instance. And at paragraph 21, it said the reason for that is because facilitation is not enough for tortious liability.
Right.
That's the first point. The second is, I didn't follow yesterday on so as to eat into time as to why the unagreed bundle had been prepared, what's in it and what it exists for. I've been encouraged by my client and have done it, and I understand why I've been encouraged, to set out a short table which at least explains what the constituent elements of the content are and why they may be relevant, so that if the court has any regard to look at the source documents, they are there. They are principally source documents which explain what the trial judge was addressing at paragraph 158 of the judgment. So in particular, why did Northamber stop supplying D3 what caused it, and what were the consequences. That source documentation.
Sorry to interrupt you, but paragraph 158 is all about the facts. Now, number one, who's appealing the facts? Nobody. Number two, why would we be concerned to go behind what the judge has found anyway?
The reason I've done it is this. When I said yesterday that this court may agree that the conclusion in respect of justification is not safe, it's not rigorous enough, and it's not complete enough, if that finds favour, then the ability to look at the source documentation which is behind the manner in which the judge got to a conclusion on justification could be of relevance. We submitted yesterday that if we're right that the justification defence dismissal is not safe, then there may have to be a reconsideration by remittal. So the source documentation in the table, the population of the table is just to explain what the constituent elements are.
Right.
So that just leaves costs. Where we say that even if there were an error of principle, and the error of principle that the appellant identifies is the alleged defiance of the district judge Rawlings order, that if you decline to engage in mediation, you must provide a witness statement. Even if there was that error of principle, we say that's not enough. For a cost appeal of this nature, the appellant has to lead the court to a conclusion that the trial judge has gone seriously wrong on the discretion on costs, and nothing that the appellant has submitted would go that far. See Straker against Tudor Rose, which I've cited in the skeleton. But in any event, the appellant says in its skeleton there was a refusal to countenance mediation, which is probably a little bit overblown in the sense that, as my Lord Phillips pointed out yesterday, there was merely one invitation. It was never revisited. But more importantly, the judge heard full submissions on that point as part of the cost and consequential hearing, and reached a conclusion that the invitation to mediate was not all it purported to be, and was motivated by tactical reasons rather than being a genuine and sincere invitation. It's difficult for the appellant to just ignore that conclusion of the judge after receiving tailored and dedicated submissions on the question of costs. Still further, the defiance of the district judge Rawlings order would not, on the face of the judge's conclusions, have made any difference anyway. So even if you reverse the alleged error of principle and inject it back into the reasoning is so strong, clear and robust by the judge that it's already clear that it wouldn't make a difference. Otherwise, I repeat without elaboration the review of the run of cases at paragraphs 27 to 31 in my skeleton.
Yes.
Perhaps particularly, which is not binding, of course, but it's a reported decision, is Honour Judge Cook in Lynn against Borneos, LLP. If there is an alleged unreasonable refusal to mediate in the first place, then the sanction for that ought to be proportionate, and more particularly, proportionate to the degree to which the court can realistically infer that there was actually an opportunity to save costs. So instead of there being any sort of dogma on if you mediate, expect a heavy penalty, it's designed to be more nuanced and fact sensitive, and that may be an attempt to state a point of principle which this court agrees with. Otherwise, the only other plank for the cost appeal is on alleged dishonesty by Mrs. Corr, but as this court has pointed out yesterday, there was simply and fundamentally no finding of dishonesty against Mrs. Corr.
There was no finding that she gave dishonest evidence in the trial before Judge Rawlings.
Yes. So the judge said that she had not been candid in the manner in which she expressed her knowledge to Lloyds about the nature of the cross guarantee, which is collateral to the concept of dishonest evidence in the course of the proceedings, which would be a matter that's engaged by Part 44 CPR. even if there had been a dishonesty finding, the 20% reduction is within the range of reasonable disagreement in any event. So, my lords, that's all I wish to submit in respect of ground 5.
Thank you. Richard, anyone? Thank you very much. Yes, Mr. Ingham.
Thank you very much, my lords. Just on one very small matter of housekeeping, my Lord Justice Arnold's clerk got into contact with me via my learned friends about a Word version of the skeleton argument that's prepared, that's in the bundle. I have now sent that through this morning.
Right.
And I regret that I wasn't able to do that yesterday after close of play, but I have now submitted that at about 9:30 this morning, so that will be available to your lordships.
Thank you.
When you come to consider your judgment. The first thing that I would like to address your lordships on are the 2 applications. I don't propose to spend a long time dealing with them, but I think it's important for me to set out my client's view on the application. First of all, for permission to amend the grounds of appeal to include the appeal arising from the slip rule, if I just call it the slip rule appeal ground. And then secondly, the application yesterday made by my learned friend leading counsel for the appellant in relation to the amendment and the introduction of ground 7.
Yes.
In relation to the application that was made on notice, albeit late, my opposition in relation to the slip rule really centres around the purpose and the effect of allowing the arguments to happen. So I am really talking about the merits. My Lord Justice Arnold raised yesterday 2 points of relevance in relation to that. One of them was, the question was posed, what practical difference does this make? Because if it's purely academic, then what's the point? And then second of all, there was the point made that this was a matter that pertained to the first defendant only and not the second defendant. It's not something he had standing to bring. And I wanted to just address that very briefly as well, because both of them are relevant, I think, to the decision of whether you consider the ground.
They're entirely separate questions, aren't they? Because the first question, that it's academic, is a reason not to entertain the application. The second question goes to the merits of the application if it's entertained. Because at the moment, to be candid with you, it seems to me that if it is entertained, there's very little answer to it, for the simple reason that the application was made by your client at a time when he was no longer a director and therefore had no authority to make it. The application had to be made by the liquidators. If made by anybody, they didn't make it.
Well, my lord, can I jump straight to those points then that you've just put to me? Because I think there is some...
I understand why you might say it's academic and therefore we shouldn't entertain it.
I'm grateful, my lord. Well, I think I won't touch on the academic point because that has already been explored. I will, however, try to deal with the point that you just raised because it was of considerable concern to me, because I was, of course, involved by this point, that the application that was being made, as you say, related to an issue which ought, if at all, to be taken up by the first defendant and not my client, because, as you say, he wasn't a director. The rationale was twofold. I think, one, I would submit that there is still a common interest of any party to a hearing in the accuracy of an order. And I mean that very narrowly in the sense that there is an interest in the order accurately reflecting what the judge has said. And I don't go any further than that. And second of all, and this was one reason that was given to the learned judge at the time as to what it had to do with my client, there is at least some conceivable scope for that mistake, we say, having an effect on my client, because although the issue of liability and the issue of the order reflecting the amount that was owed is principally for D1, as a former director of D1, my client still, I would submit plainly, could have had an interest later on if his conduct were called into question by the liquidator, I don't want to develop this too much, but
But how can that any longer be the case in circumstances where the liquidators are no longer in office and have not launched any application against your client?
so, my lord, yes, it's right that they're no longer in office, and that certainly diminishes the risk considerably. But I would say it's at least conceivable that there could be an application brought by an office holder against my client. And at that stage, I submit it would have done him absolutely no good at all to say, well, the order has on it a plain mistake, because by that point in time, we would be too late and we would have gone past the point when the judge was actually considering the question at the time. And I think if my client's conduct were being called into question in relation to this, so I'll be plain about what I mean about that. If a cause of action was being launched against him under, for example, the Insolvency Act.
Does the company still exist? Or has it been dissolved?
It doesn't exist anymore, my lord.
So somebody would have to restore it to start with.
Yes. Now, I'm not trying to suggest, first of all, that it's likely on the basis of my client's conduct. But what I am trying to do is explain why my client had a concern and why I don't think it is entirely without his, if you like, interest to challenge the plain mistake. I can put it no higher than this, my lord, and then I'll move on. If at a future date my client were being called upon to contribute in some way to the funds available to creditors, however unlikely that may be, I would submit that it would do no good at all to say, well, there was a mistake at the time, but it wasn't for us, it was for D1 and they weren't represented. But now I'd like to go back in time, in effect, and argue over this. I think we would be told, rightly in that scenario, that it was an issue that ought to have been raised at the time.
Right.
However unlikely that may be. But in terms of the merits, I would, if you like...
It's plainly not within the slip rule anyway, is it? I mean, the judge has come up with a whole bunch of reasons for a different figure, all after the event.
But my lord, Lord Arnold, I think if that was correct, if it was a substantive difference, then there would be merit in that view. But my submission is that this is an example of the learned judge giving a clear direction to the appellants not to include the so-called Vietnam figures, and I hope that my use of that shorthand is understood, not to include that in the quantification or into the figure that is on the order. The order was then sent in draft following the hearing to the advocates. It wasn't agreed. So this isn't a situation where the advocates all agreed or didn't read it and there was then sort of buyer's remorse later. It wasn't agreed at all. And it was then sent to the learned judge who approved it. So the reason we couldn't agree to it was because we said it was wrong, because it doesn't reflect what the judge told the appellant to put into it. The reason that the slip rule application came about, and now this, I don't want to delve too far into giving evidence, but my lay client raised this issue about the inconsistency of what was put on the face of the order with the judge's direct oral admonition to the parties. It was at that point that the learned judge said to my client through his clerk that an application should be made under the slip rule. I accept that that doesn't therefore mean that any concern that my Lord Arnold has raised falls away, but that is just the explanation of how it came about.
Well, it might have been better as a 3.17 application to vary the order rather than slip rule.
My Lord, I think, first of all, that's correct, and on reflection, that probably is more properly where the matter falls, because, as I say, this wasn't a situation in which there was any request on the part of any party other than the appellant for the substance of the judge's decision to be changed. It wasn't a situation where the reasoning was being challenged, where he was being asked to come to a different conclusion. He had already come to a conclusion that the Vietnam thing shouldn't be in there.
We've got that point. You say that he excluded what you called the Vietnam figure, and that was erroneously included in the calculation of quantity.
And perhaps the answer to my Lord, Lord Justice Arnold's point is in what you've said, my Lord, which is that perhaps the jurisdiction under 3.17 to revisit even final orders in various different scenarios may have been more appropriate than the slip rule. The reason that it was put in that way was because that was the request put by the judge.
Yeah.
I think I can sense probably that I've said all I can about this, and I may move on to the second application, which...
This is the ground 7 application.
Yes.
Yeah.
The starting point for my submissions, my lords, is what you said to my learned friend yesterday in his presentation about the relief from sanctions criteria, because necessarily what one has to consider is the Denton test. And if I may say so, I don't believe that my learned friend said a great deal. Of course, we don't have, as we would normally, any witness statement from...
Well, can you help me on this? Are you
Yes.
able to cite any authority where the Denton test has been applied to an application to amend grounds of appeal? It's certainly been applied to late appellants notices, but off the top of my head, I can't think of any authority which has applied it to an application to amend grounds of appeal after permission to appeal has been granted.
So, my lord, that's correct. I have also looked, and your summary is accurate. There is no reported example of the Court of Appeal, or indeed, I think, any other court, refusing permission in these circumstances that we're concerned with here. So I couldn't say that. But what I can, of course, say is that I need not even, I think, address you on the first 2 limbs of the test about the...
Yeah, but why does the test apply at all? So you've accepted there's no authority. Why in principle? Now, the reason why it's applied in the context of a late filing of an appellant's notice is because of the doctrine of implied sanction. So there's no express sanction in the rules, but the reasoning in High Search and other cases is that there's an implied sanction, which is, unless you've got your extension of time, you can't proceed with your appeal. And so the implied sanction is you're debarred from pursuing your appeal. Now, do you say that that reasoning applies here? Because the appeal will certainly proceed anyway. The question is, on what grounds?
So, my lord, I think I would say yes, but perhaps not as mechanistically as it's being put. So what I would say is that plainly the circumstances surrounding the making of the application to amend the grounds must be relevant to the exercise of discretion. So it was already pointed out that for several months, my learned friends have been aware of the counter-argument, if you like, which
but
gives rise to this.
your main point, surely, is that this is a very late amendment. It's about as late as it could possibly be.
Yes.
It was made halfway through the appellant's submissions.
Yes, I mean, I want to say it was egregiously late, and I think that's probably appropriate because it was done at a time when realistically, myself and my learned friend don't have the ability to consult with those who were acting at first instance, and don't have the ability to properly think about what the response ought to be to the reformulated
Well, we've got that point.
My lord, if you've got that point, I don't think I'm really resisting it on any other basis. So to conclude then, our position is that both applications should be refused.
Yeah.
So what I'll do now is I'll move on to the grounds of appeal. Raised by my client in our substantive appeal. So the starting point for our appeal is ground 2, which I have called throughout my submissions the irregularity ground. My lords have already heard a great deal in questioning and exchange with my learned friend, leading counsel for the appellant, about the circumstances in which findings were made and liability attached to my client arising from the allegation that he was acting either outside the scope of his authority or in a way that was not bona fide. So we know already that the basic starting point for this ground is the recognition in the judgment that not only was it not pleaded, the particulars of claim didn't plead the relief on the basis that an exception to the general rule ought to apply in respect of Mr. Singh, and that he was personally liable because he was acting outside of his authority or with, if I just say malafides. But it's worse than that. It wasn't put either in cross-examination.
Yeah, but they're two separate points, aren't they? Because so far as procedural irregularity is concerned, that pleading point potentially goes to that. But not putting cross-examination, I mean, that's more a point on the merits of it, isn't it?
My lord.
And if you don't mind, I'd quite like to compartmentalise those two questions. I appreciate they're both live. But so far as the pleading point is concerned, the judge deals with that at paragraph 230, and there's no dispute it wasn't pleaded by Northamber. But the point was raised by Mr. Brown, then appearing. It wasn't pursued. And what do you say to the point that I bring to Mr. Coppell's attention, which is that Hawksworth and Chief Constable of Staffordshire, which you'll find cited in the White Book at paragraph 16.0.1, tells us that if you don't insist upon the pleading point at trial and obtain a ruling from the trial judge, which puts the claimant in a put up or shut up position, then it's too late to pursue it on appeal. What's your answer to that?
So I don't have a direct answer to why it was that my predecessor didn't take the stance of insisting on the resolution of this pleading question before His Honour Judge Rawlings proceeded to give his judgment. I think what I can say is it's been agreed already.
I'm sorry to interrupt you, but the reasons why he didn't or didn't insist on it are neither here nor there. The fact of the matter is he didn't, and the consequences flow. And that's my question to you. How do you avoid the consequences?
So, my lord, there is a certain level of nuance in the types of pleading complaint and the way in which they may be resolved, if I can put it that way, because there will be some instances, I would submit, in which a complaint about improper pleading requires, on the part of the person complaining, to litigate an application to strike out and to insist upon a resolution at that point. And what I would say is the opposite scenario here, where a constituent element of what the appellant or claimant was asking the judge to find simply wasn't reflected in the pleadings. And I don't think I would accept or agree that the failure to insist on a remedy, I've already said, I think that strikeout is difficult because there wasn't anything to strike out.
That's a distraction. I quite get your point that strikeout might not have been the appropriate remedy. But in simple terms, what you are able to say is that Northamber was pursuing an unpleaded claim. But the judge let them do that. And what Hawksworth says is, if there's been an objection and insisted upon, then you've got a ground of appeal, because there would then have been a ruling by the judge allowing an unpleaded claim to be pursued, and you simply say, that's wrong. The judge's ruling allowing the unpleaded claim to be pursued is wrong. We overturn that, and then that's the basis for the appeal. If you don't insist on and don't get the ruling, it's too late to take the point on appeal.
The difference, of course, here, my lord, is that in fairness to my predecessor, the point was pretty squarely raised at the outset. And the judge's response was to say two things. First of all, that application to strike out may need to be considered. And second of all, this is something that I can take up at the end. And I would ask that the court also consider in the closing submissions, from my client's counsel's perspective, that the argument wasn't put by them and they didn't deal with this in closing. They didn't ask the judge positively to make the.
I mean, you may be able to say, well, where the draft amendment to plead bad faith wasn't insisted on by the claimant and it wasn't put in cross-examination, the only reasonable inference was that case was no longer being pursued.
Yes, my lord, and I think that's perhaps a better response to the point that was put to me by His Lordship Lord Justice Arnold about where the difference lies and where the difference in emphasis is. Because, of course, we're not talking about a situation where there was an analogy I was going to make some reference to in regard to my Lord Lord Justice Arnold's questions to my learned friends about the burden and whether this was a defence or whether it was something.
Well, I think Mr. Coppell accepted the burden was on the claimants to show that your client was acting in bad faith or outside the scope of his authority.
Yes. I was going to draw an analogy with, for example, claims that are brought against trustees or office holders where they have a statutory defence that they can put forward on the basis that they were acting, for example, honestly and reasonably. And in that situation, it would be, yes.
Whereas you're in a more advantageous situation.
Yes. My lord, yes, it appears I don't need to go and address that any further. But the difficulty here, of course, is that the claimant is the one who has the obligation to explain to the judge what it is they want them to do with the case they have before them. And this is a pretty clear example where it's been raised as an issue at the outset that there's no pleading in relation to the personal liability of my client on this particular basis. We then have the cross-examination, it's not dealt with, and then we then have closings. Now, a counsel of perfection, you may say, oughtn't it be sensible at that point still to say, I'm not happy that this has been left in abeyance. I bring this to your attention. This hasn't been pursued, it hasn't been put in cross-examination, so you can't make the finding. But I don't think that the failure to do that is analogous to the circumstances that my Lord Lord Justice Arnold is positing about the failure to insist upon a ruling in certain allegations of poor pleading or insufficient pleading.
Yeah.
One possible way of looking at it is to ask what prejudice the litigant suffered. Now, so the way the judge approached it was to divide it into 3 periods. And so far as the first 2 periods are concerned, he was in your client's favour. So you've got nothing to worry about there, is concerned. And obviously there's the argument from Mr. Coppell as to why the judge was wrong on that. But assume for present purposes that we're not with Mr. Coppell on that, then your only concern is with the 3rd period. As to which, subject to the points to which you are coming on issue and so on, why is your client prejudiced? I mean, if the judge is right that, and I haven't seen any argument to say that he was wrong, to say that Genee World was in breach of the injunction in that period, what possible answer to it would your client have had?
So one of the difficulties in this case, of course, is that in any event, if it is right that my client was fairly found to have been in breach of his injunction, that necessarily that isn't capable of excuse by reference to whether he's acting bona fide or not. And to some extent, that provides an answer to the question, my lord, that you put. However,
sorry, just let me understand what you're saying. You're saying if Genee World was in breach of the injunction, as Judge Rawlings held it was, your client could not have been acting in good faith and within the scope of his authority in causing / allowing Genee World to breach the injunction. Is that
Well,
that's what you're saying?
I would row back from that in this way, and I would say that clearly you would have to have the inquiry as to what the circumstances were, and it would of course depend on the reasons why the breach took place, and there'd have to be a fact-sensitive inquiry. So I don't think invariably it would always be the case that one would be acting in bad faith, but clearly it's a very difficult charge to answer. The difficulty here, of course, is that the lack of analysis in the claimant's case, and I mean that by way of pleading and cross-examination, is that there wasn't attention given, and my client wasn't given the opportunity to explain, for example, what his understanding of his duties might have been, what he says to any allegation that he wasn't acting within them, and what he says to any allegation that he was acting in bad faith or in a dishonest manner in this context. He wasn't given that opportunity. And that's part of the reason why we say it's a procedural irregularity.
But let's assume that he was acting in good faith. What's the answer to the point that it can't be consistent with the duties of a director to allow his company to act, to cause or allow his company to act in breach of court injunction? There can't possibly be any answer to that, can there? Even if he's subjectively acting entirely in good faith.
I think it does depend on the scope and the formulation of the exception within the rule. I accept that the starting point of the argument is that if a director is causing their company, his or her company, to act in a way which breaches an injunction, then there's going to be a very strong inference, but there's going to be a starting point that they're not acting in good faith.
No, this
But
is
in your
sorry, the purpose of my question is, and maybe you're not accepting the premise of my question, in which case I ought to ask you whether you do accept the premise of the question, because my understanding of the rule at the moment, and if you're arguing to the contrary, please let me know.
yes,
Is it's a disjunctive requirement. It has three elements in it, which operate independently. One, the director must act bona fide. Two, the director must act within his authority as a director. And three, the director must not be breaching his duty to the company. Now, let me ask you about the premise. Do you accept those are three independent requirements?
no, in respect of the last one posited, that what I would say is that I don't accept that in any instance where there is a breach of an obligation under the Companies Act, and I'll be coming on to this a little bit later, but don't accept that that necessarily means that the exception applies. So to put that another way, I don't accept that invariably a breach of a duty under the Companies Act rules out a finding that you're acting in good faith or within the scope of your authority.
But sorry, I don't quite understand that. Because it's one thing to say that the third element may involve questions of degree. It's another thing to say there's no third element at all.
Well, my lord, I wouldn't say that there's no third element. Of course, it's incumbent upon the court to look at the circumstances, and very often when there's a consideration of if the director is acting bona fide within their authority, clearly the court is going to have regard to what their statutory duties are, including to Section 172, and to whether or not they've acted in accordance with them. What I push back against is what I say is the learned judge's formulation, which is that will always be the case, e.g. any breach of statutory obligations means that the exception applies and therefore they're personally liable.
All right, I think I've understood that, but can I be clear? Is it your submission that all the director has to show is one, that they acted bona fide, and two, within the scope of their authority?
Yes.
So no matter how egregious the breach of their statutory duties to the company, they're still protected.
well, the egregiousness is going to come into the question of whether they're acting bona fide or not, I would say. So I think that's the answer to that point. I'm not suggesting it acts in a blanket sense.
What authority does a director have to cause the company to breach an injunction?
So the breach of the, again, the breach of the injunction example is different from the breach of the contract. I accept that. And yes, I'm not suggesting. I think the difficulty here is that, that there's of course overlapping challenges that my client makes.
I mean, you can certainly imagine a director saying, well, we've got this injunction against the company. It's really causing the company an awful lot of harm. So
Yes.
it's definitely in the interest of the company not to comply with the order. So we're not going to. Now, that would be bona fide in a sense, doing what was in the interests of the company in a sense. But what authority does the director have?
Well, this is why I think this comes back to the procedural regularity, because of course if there'd been a focus on these questions, my client would have had an opportunity to explain his position about the underlying breaches, because here, and I'm not making a factual case here, but the court will be aware from the refused first ground of appeal that his position evidentially was that these sales didn't happen and they couldn't have happened. And the basis for the finding was on inference, because it was a reference to, you'll recall, the deleted Sage entries, and then second of all, evidence given by my client's expert, Mr. Pinn. Now, I'm not saying that I get to escape from that, but what I do say is that part of the irregularity in my client not having the opportunity to answer directly questions about acting within scope or bona fide is that he has in effect been limited in his ability to answer that. Now, you could say, well, are you not there saying that the finding is wrong? And that's the issue. And that's what our ground one was that was refused.
So you've been refused permission.
Yes, and I'm conscious of that. And I would say the procedural regularity still has to come into.
I mean, you've been refused permission to say that the finding is wrong. But you may be entitled to say, I think you are saying, the finding may well have been right on the material that was before the judge, but if the point had been flagged and put, there might well have been different material before the judge.
Yes.
And that is the procedural irregularity.
Yes, and that is why I have some reluctance in agreeing with my Lordship's Lord Arnold's point, because on the material that's available, yes, these conclusions are inescapable in many respects. But part of the purpose of having a properly pleaded claim with the opportunity to answer in cross-examination is that the judge, it shapes the material that's before the court and that's before the judge.
Help me on that. And there's two questions. One, why is the scope of the director's authority not a question of law?
The scope, so I think it's a difficult, well, I'll put it this way. So the Lord Justice Lewison's point, or hypothetical earlier, about whether or not it was ever possible for a director to cause his or her company to breach an injunction and for that to be within the scope of their authority. I realise that it's a difficult argument to say that there are circumstances in which they could direct their company to breach a court order and for that to also be within their authority. So I have to acknowledge that there's some difficulty there. I think the thrust of my point in the highest I can put it is on this basis about the material that's available to the judge in making the findings.
So you would accept that the scope of the authority is a question of law, and
yes.
I take your point about procedural irregularity. I think I understand now how you put it, but can I ask you this question? Can you dispute that the question of whether the sales were in fact made or not was investigated at trial? There was evidence about it, and the judge did make a decision.
This, and again, I can I think sense my lay client's response to that question, because of course this is part of his focus on this appeal as to the underlying merits. That there was investigation into this question of whether the sales had taken place or not. Yes. Now, the difficulty is, as I say, this isn't a case where a finding was made positively on the basis that, well, I mean, the judge's finding, of course, is a finding of fact, which is that they took
Because
place.
it was part of Northamber's case anyway. I mean, the fact that they had been in breach of the injunction was, as it were, an additional factor for their relevance of those sales, but it all went to quantum apart from anything else. Because Northamber were saying that all of these sales were a breach of the exclusivity. And so the question of whether they were or whether they had taken place at all, and if so, to whom, that all went to quantum part of the else. So this was all in play, wasn't it?
I would say no, it wasn't all in play at all, on the basis that the focus of the cross-examination that my client was subjected to was not upon his specific duties as a director and what he did or didn't do in his role as a director. I mean, I appreciate, of course, the allegation was made and put to him that the sales had taken place, and he denied it.
So you
But
accept the
difficult-
allegation that the sales had taken place was put to him.
Well, may I turn my back because I can hear my lay client wanting to pass instructions on to me. I'm grateful to my lay client who confirmed what I think the answer was. What was put to him was he was taken to the Sage transactions. So there were 4 instances in the Sage transactions. He was taken to those, and it was put to him that he had deleted them.
Yes.
And his response to that was that he had not.
And the judge found he had deleted them.
Yes, and I would suggest, though, my lord, that in coming to that conclusion, the result may well and could well have been different if the claim had been pleaded properly, because the complexion of the evidence before the court may well have
I
been.
don't understand that, because this was something that surfaced on the experts' reports, apart from this. I don't think it might have surfaced in other ways. But the experts' reports revealed this difference, and then it was flagged up in the joint report.
Well, my lord, I would push back on that in this way. That the way that the allegation found to be proved by the judge came about in 2 ways. First of all, there was the finding by inference that my client had deleted the transactions, and that was made more generally by reference to his credibility, I would suggest. Yes, Mr. Pym was asked questions about this, and in particular, it was asked of the expert, isn't this a unique thing they've done? And what I mean by that is Mr. Singh's explanation was that the orders were inputted and were originally genuine in that these were meant to be sales that would take place, but that they were later cancelled. And the questions that were put to him revolved around, or rather, the criticism, if you like, that was taken of that was of the nature of, well, surely that's an unusual way of dealing with matters, because wouldn't you issue, for example, a credit note, or wouldn't you take some other step to rectify the position as opposed to just deleting the Sage entries? And that was put to the expert, Mr. Pym, who, under cross-examination, conceded that it was unique. So that's the word that was used. I don't think it would be fair to say that Mr. Pym went any further than that. And it's really that, it's the nexus of those 2 things which then leads the learned judge to make the
Doesn't
conclusion.
this discussion reveal that the issue was investigated at trial? There was cross-examination of your client about it, there was cross-examination of your client's expert about it, and the judge made a finding of fact.
But the finding of fact comes about through an analysis of my client's credibility, which I would submit
Not just that, because there was the documentary evidence and the expert evidence.
I would say, my lord, that it was very heavily influenced by credibility as opposed to direct evidence. Because the explanation is given by my client in his evidence as to why there are these 4 deleted entries.
The judge didn't accept that evidence.
part of the reason he didn't accept it was because of what was put to the expert, Mr. Pym, about whether that was Mr. Singh's explanation reflected a regular way of doing things or a
Yeah,
normal.
well, that's a perfectly legitimate thing for the judge to take into account in assessing the accuracy of the evidence, isn't it?
But the difficulty is in my submission that when the learned judge was considering this question, it's clearly one of credibility, and whilst I accept, yes, the judge is entitled to take account of and have regard to the way in which the witness performs, the way that they give their evidence. The difficulty here is that the learned judge was considering in essential a different case, because what we're looking at is the personal liability of Mr. Singh, which hangs, of course, on the exception to the limited liability principle. So, if a finding of that nature is being made, it's my submission that it's imperative that the case ought to have been put fully and properly before to my client when being cross-examined. And the way in which it's pleaded, the way in which it's set out, informs the way in which the case is litigated, and that includes putting together the witness statements, calling witnesses, and presenting the evidence. I don't think I can put it any further than the comment earlier you made, my lord, regarding the, if you like, the shape of the material in front of the learned judge.
Yes.
The only thing I'll add to what I've said on this ground is that I am to some extent echoing the comments that have already been made yesterday in my learned friend leading counsel submission. If my client was being accused of not acting in a way that was bona fide or in a way that's dishonest or in other ways discreditable, then that should have been put fairly and squarely, and it wasn't. I should also say that there was a suggestion about the framing of the listed issues and whether that could be said to be curative of the problem, because one of the issues that the judge set down after hearing submissions at the beginning was this question of whether or not my client was acting bona fide and within the scope of his authority. And my submission is that, of course, doesn't cure the absence of cross-examination on the point.
Yep.
Even if it could be said to, I don't accept this, but if it were said to remedy the pleading point.
Right, we need to move on a bit.
Yes,
Mr.
I'm
Ingham.
aware, my lord, and I apologise. I will seek to increase the pace of my submissions. So the third ground relates to what I've called in the submissions the issue of estoppel. I think I should start this ground by setting out what I think the challenges are that perhaps I will have to meet in answering your lordship's questions, because it will no doubt be said that whilst there were committal proceedings brought in relation to specific allegations of breach of the injunction in the committal proceedings that were not made out, the orders and the matters that the learned judge was considering, and which eventually led to my client being liable, were obviously different than those in the committal.
Not only were they different, Ashworth specifically excluded them on the basis that they were too late.
Yes.
So there was no decision on the merits.
So, no doubt what will be said is, not only wouldn't it have mattered if the learned judge had considered them all, because what was being considered was a criminal matter, and whether the burden of proof at the criminal standard had been met as to whether my client was in breach. But, as my lord, you've said, that they are different instances.
You have to show that Mr. Ashworth decided it. And in relation to the excluded matters, he can't possibly have done it because he excluded them.
Well, my lord, what we will say in relation to that is, and I think I'll take your lordships to his judgment and the course of the event, because you will recall that the applicant chose to present their application on the basis on a broad basis.
This is the application for committal.
Yes. So if we turn now to the committal judgments, which
So in the supplementary bundle now, are we?
yes, it's also, I believe, in the core bundle as well. But
I think we've got it in the supplementary bundle.
yes, you have it in the supplementary bundle, so it can be considered alongside the core bundle.
Yeah. So what are we to look at?
I'm looking at
Mr. Ashworth's
the-
judgment?
yes, and I'm looking at paragraph 61, where he considers the grounds that were advanced by the applicant in their application of committal.
Well, don't we need to start a bit earlier in the judgment, because at paragraph 37, he explains about the application for permission to amend the grounds substantially. And he goes on to explain why he refused permission to amend, and therefore none of that material came in.
Yes, and what I will say is part of the doctrine in relation to estoppel, and the reason why there shouldn't be repeated attempts to litigate issues, is inherent in the, if you like, oppressive nature of the process, or in the effect that it has on the respondent. And if I can hopefully just make this one statement of principle and then I'll answer questions about it afterwards. But it was the applicant's choice to make an application to commit my client for contempt on a broad basis. So it isn't just on the 4 examples that are cited at paragraph 61. They also, in their application, applied to commit my client on the basis that they said the claimant knows of the incident stated above but believes there'll be many others. That's right to say, of course, that there was criticism made of that, an acknowledgement that it couldn't amount to a proper allegation of contempt, but the application was still made to include the grounds which did end up being the subject of His Honour Judge Rawlings' decision.
I don't
Now
understand that submission, because the deputy judge dealt with the 4 specific instances that were particularised and rejected them. So far as the other instances that they sought to rely on by amendment, he didn't allow them in, so he didn't consider the substance.
Yes.
So where's the issue estoppel?
So, my lord, it's not my suggestion that there's an issue estoppel in the sense that
That
the
is your
decision
ground
was
of
made.
appeal. I'm sorry, you're on ground 3, and if the ground of appeal is issue estoppel.
You haven't put it on the wider Henderson and Henderson. This could and should have been adduced in the committal application. You haven't.
No,
argued
it is
that.
not put on that basis, no.
No. So your issue estoppel, and as my lord says, issue estoppel applies to issues which have been decided.
Yes, my lord. Can I briefly turn my back for a
Yeah.
moment? So, my lord, I'll move on, but before I do that, I'll just make the following comment, which I make on instructions from my client, which is that the original contempt proceedings involved an allegation, of course, that he had breached the injunction in 4 material respects.
Mhm.
And of course, the judge found that that wasn't made out and made positive findings about it. But we accept, or I think I'm driven to accept, that the orders that eventually came to be considered by the learned judge, which did lead to the liability, are separate and are not the same as the ones that were dealt with in the committal stage.
Yeah. Right, so that's ground
Right.
3.
And I should say, my lords, I don't propose that I'm going to be taking longer than the lunch break, so I have got the timing in mind, and I'm not.
Well, Mr. Coppell needs to have time to reply before we break.
Yes, my lord, I think I was saying I'm not going to be taking longer than he
All right.
took, which was a morning session. So ground 4 and 5 are clearly related, but ground 4 is clearly a more expansive ground, and it's the one that was described by my learned friend leading counsel for the appellant, I think, as being more ambitious or courageous. I can't remember the exact word. But the reason for that is because, of course, it's not, if you like, a plea to authority or a suggestion that there is a textual analysis of authority which would lead the court to conclude that the formulation of the exception to the rule in said and but is as I say it should be, as is as encapsulated by the dicta, well, I shouldn't say dicta, by the judgment of Jane Crystalens. So I want to be clear that I suppose this ground is slightly more amorphous than perhaps would ordinarily be the case in arguments heard by this court, because I'm not suggesting that the statement at the bottom of paragraph 31 of my skeleton argument in Crystalens is necessarily at present a reflection of what the state of the law is. Now, what I mean...
Sorry, I thought that was your case, so,
Well, no,
so please tell us what it is.
I'm grateful, my lord, and maybe I should put it this way. So, the formulation arrived at in Crystalens was as follows, and the quote that I emphasise in
Yeah,
skeleton is...
you've quoted it in your skeleton.
Yes.
But could you explain how an employee acting bona fide in the interests of his company could be dishonest? We'll put it round the other way. How could a dishonest employee be acting bona fide?
So the reference to vicarious liability that I made there was more of a focus on whether someone was acting within their authority as a director or qua director.
But if there's this additional factor of dishonesty, what does
Yes.
it add to acting in good faith? How can you be dishonest and in good faith?
So my answer to that is my lord is correct, but that does not mean that nothing is added by the additional qualification that I seek to put on it. So yes, invariably, where someone is dishonest, I would submit they're not going to be able to demonstrate they were acting in good faith. But the reason that the qualification makes a difference, I would submit, is because it emphasises that something else other than just being in breach of either an obligation to the company or inducing a breach of contract, something additional to that is required.
Sorry, can we go back to the beginning here? And I apologise, it may be my confusion. In the skeleton, you were
Yes.
very clear that you were saying that what Mrs. Justice Gloucester, as she then was stated in Crystalens, was a correct statement of the law.
Yes.
Now, do you maintain that or do you not maintain
No,
that?
I do maintain that.
Okay, so that then leads on to the next question, which is when she says additional features such as conspiracy or dishonesty are required, is it your submission that only conspiracy or dishonesty will do?
Yes, my lord.
Fine, thank you. And on what basis do you say that only conspiracy or dishonesty will do?
the starting point of my submissions is this. The fundamental starting point is that there isn't liability imposed in respect of directors for actions that they take in respect of inducing the company to breach its contractual obligations. And the question that said and but considers is the circumstances in which that there will be an exception to that rule. In this judgment, in fairness to the learned judge, he undertakes a review of the authorities that consider this question.
Crystal Lens, on my reading at any rate of this extract, is actually cutting down the scope of side and butt, isn't it? Side and butt says, if the director is acting within his authority and bona fide in the interest of his company, he is not liable. Full stop. Mrs. Justice Gloucester says, well, he may be if there are additional circumstances, such as conspiracy or dishonesty. Well, we've discussed dishonesty. I don't see how that squares with bona fide. So she's cutting down the scope of side and butt, is she not?
My Lord, yes, I think that's certainly a reading of the judgment. I should accept, of course.
And you say that's right, because you, in a reply to Lord Justice Arnold, you said she's right. So side and butt
Yes.
is cut down to some extent. We don't know quite to what extent, but to some extent.
I think the difficulty is that I'm approaching this from a slightly different perspective, which is that the formulation that the learned judge approaches applies in this case, and the formulation that is applied in other instances, is much more expansive than that, which is to say that in any case where there is a breach, for example, of a statutory duty...
You better just remind us, what does the judge actually say? Can
Yes,
we be reminded of that?
I will take you to it now.
He starts his discussion of side and butt at paragraph 221.
Yes. The principal...
227 is his summary.
The principal analysis is between 221 and 227. 228 is where he then goes to apply facts.
So it's 227D that you object to, is that right? Mr. Singh will not be acting bona fide if he acts in breach of his duty under the duties under the contract.
Yes, and that...
You say that's too expensive.
Yes. And I accept that comes more under the arguments we're making in ground 5, but yes, that is too expensive.
Right.
Because Section 172 clearly is quite broadly drafted in terms of the types of conduct that it can cover and the types of considerations that it can cover. And it's my submission that it would be too far to conclude that any breach necessarily then means that the exception applies.
Suppose that instead of saying Mr. Singh will not be acting bona fide if he acts in breach of his duties under the 2006 Act, the judge had said Mr. Singh will not be acting within the scope of his authority if he acts in breach of his duties. Would that make any difference, or would you accept that is right?
I think it does make a difference, my lord.
Well, let's suppose then that the judge had said Mr. Singh will not be acting within the scope of his authority if he acts in breach of his statutory duties. You've accepted, I think, in response to Lord Justice Arnold, that good faith and authority are both part of side and butt.
Yes.
Whether we call it a defence or an exception may not matter. So, if you accept that acting in breach of statutory duty is not within the authority of a director, the fact that the judge characterises this as bad faith rather than lack of authority makes no substantive difference, does it?
Well, I think it does make a difference because the reference to acting outside of your authority is a particular inquiry which is directed at what it is that the director is doing and whether or not it's something that arises in their role as a director or not. And that's is perhaps misplaced, but the reference I was making to vicarious liability in the skeleton was to say that that is what is meant by acting in the scope of authority, that you're acting qua director, not the bona fide part is clearly a qualitative assessment of what it is that the action is. So clearly it can be within the scope of authority, but in bad faith. I mean, an example of that may be the points made in the analysis in Antusis, which is considered by the judge, and it's from paragraph 225 of his Honour's judgment. I should say that both Antusis and IBM, there are copies of those if it becomes
Yes.
necessary to look at them, but I don't believe it will, because the relevant passages that are cited here. But there is a reference to a difference between, for example, on the one hand, not paying a supplier on time, and on the other, lying and supplying burgers made of horse meat instead of beef, on the basis that the horse meat is cheaper. And the distinction between those two is because in the second example, the resulting scandal would be at the very least likely to inflict severe reputational damage. So it may well be that the making of the statements, the discussions that one has with suppliers, whether true or not, obviously arise in the course of your duties as a director, in the sense that you undertake that role as a director.
Can you help me on this? I mean, as I understand it, you are supporting the distinction that Mr. Justice Lane drew in Antusis, and one can see on an intuitive level the sense of that distinction. But looking at it from the prism that my Lord Justice Lewison was looking at it, I mean, really late payment of a supplier, or even if it's a breach of contract, that wouldn't be a breach of director's duties, would it?
Well, I mean, arguably, it could be a breach of the duty to promote the success of the company in certain circumstances, particularly if the decision were an economic one. For example, to deploy resources to one thing rather than that. I think there could be an analysis, and this is part of the problem that I say exists in the wide and loose application of Settenbart.
So you're arguing for a narrowing, are you, Seidenbart?
No, I'm not, my lord. I'm not arguing for a narrowing of the principle. I'm answering the point that was the specific question that was asked there. I'm not arguing for it to be, well, it depends what you mean by wide and narrow, doesn't it? Because we should be clear about the nomenclature. It's an exception to the proposition that the director shouldn't be personally liable. I am arguing, yes, for a narrowing of that exception, yes. So a widening, if you like.
No.
I should be clear that that is what I'm saying. Perhaps that's why there's some confusion on my part. Yes, I'm arguing for a narrowing of it, and that's unavoidable. The reasons that I'm arguing for a narrowing of it arise because what I say is quite an unsatisfactory approach, demonstrated and actually highlighted, I think, by His Honour Judge Rawlings in his judgment. So he makes the point when undertaking this analysis.
But can I ask you about
Yes.
what's said by the judge at paragraph 226? Because what he goes on to explain was that in Antusis itself, Mr. Justice Lane found that the second and third defendants did act in breach of sections 172 and 174, in that what they were doing was not in the best interest of the company, they wrecked its reputation in the eyes of the community. So on that basis, he said there was no side and but defence.
Yes.
Now, do you accept that Mr. Justice Lane was correct, or do you say he was wrong?
I would say he was correct in that case.
In which case it seems to follow that breaching a director's duties is sufficient to deprive the director of his defence.
Yes, and I don't think that that is inconsistent with sort of my primary thesis, as it were, my lord.
Well, how is that consistent with your submission that nothing less than conspiracy or dishonesty would do?
Well, because there is an overlap between the two in so far as its application in Antusis, I would say, isn't there?
But Mr. Justice Lane in Antusis did not find conspiracy and he did not find dishonesty. And yet he said the defence was not available.
I'm sorry,
So
my lord.
if you accept
I
that he
understand,
was
yes.
right, then that's inconsistent with how you say we should interpret crystalline.
I apologise, my lord. I misunderstood your question because I wrongly thought that you were talking about the analogy that was drawn earlier, but you're not asking about the specific finding in that case. So,
Well, I drew attention to the specific finding in Antusis that's summarised at the end of paragraph 236 of the
Yes.
judgment. You have to say you have to say it's wrong, don't you?
yes, yes. And that is what I should be clear. That is why in the skeleton it's phrased in the way that it is, which is that not just the learned judge got it wrong, but also that the authorities that he considered likewise did so. I'll put it in this way, my lords. The additional, if you like, probanda that I'm arguing for, where there should be some element of dishonesty or conspiracy, arises, I say, because without it, the operation of this rule, this exception, is such that it can't properly be called an exception to a rule. If it is right, for example, that being in breach of one's obligations under the Companies Act is sufficient to deprive a director of the protection they would ordinarily have, then I would suggest it's going to be more often than not the case that the exception will apply in circumstances where a director is responsible for causing their company to breach contracts. Equally, in relation to section 172, as I've already indicated, there's a large amount of leeway, if you like, and discretion on the part of a director, and a large amount of material they have to consider in exercising their obligations. So, in particular, I refer to 172, where they have to consider acting in good faith what will be most likely to promote the success of the company for the benefit of its members. And in doing that, they have to consider, amongst other things, the likely consequences of any decisions in the long term, the interest of the company's employees, the need to foster the company's business relationship, etc. And as I've indicated, there will be plenty of scenarios, I submit, where those will necessarily come into conflict. And I would submit there's nearly always going to be some argument about whether or not a director is acting bona fide if it is tied to this question of whether or not they are in breach of their statutory duties.
It'd be very often a question in any event as to whether or not a director is acting bona fide in the interests of the company if he causes the company to breach a contract.
Yes, and that's why
The consequences.
yes, because the consequences will nearly always be that they're exposing the company to liability, and they're also exposing the company to further risk in terms of things like costs in any litigation. And this is the difficulty with this what I call wide formulation of the exception, is that it invites far too much uncertainty about the position.
That isn't the exception, that is the rule.
Well,
The rule is that the director is only protected if he's acting bona fide in the interests of the company.
well, I don't know if this is a difference in emphasis, but the emphasis I've placed has been on the fact that it's an exception to the rule of limited liability. I accept that the way said but is also put in on the basis of the law that you just outlined. But clearly it's an exception to the general position, which is that the directors are not personally liable for the acts of the company. I don't know whether there is a difference between those two.
Can we just look at the judge's reason in paragraph 253? This is the third.
253, my lord.
Yeah, this is the third period. This is where he finds your client is liable. So he says, insofar as Mr. Singh procured that Genee breached the exclusivity agreement,
Yes.
that would not be consistent with his duty under section 172.
Yes.
The reason is that he would cause Genee to breach the injunction, thereby be in contempt of court and at risk of having a fine imposed upon him, having his assets sequestrated, and would suffer reputational damage if found out. Now, as an assessment of whether the duty under section 172 was or wasn't breached, do you quarrel with the judge's conclusion?
My lord, may I turn my back? I can hear my.
Well, it's a question of law, isn't it?
It is, but I can hear my client.
Yeah, well, maybe you can, but what's the answer to the question?
My lord, I think I can't quarrel with that clearly, because I think it's right to say, isn't it, that if there is a finding which is not subject to any other challenge, that a director has caused a company to breach an injunction, then clearly I would say there's not going to be a basis on which it can be argued.
I understand your submission that not every breach of duty under the Companies Act will deprive a director of the side and butt defence.
No.
But what about a breach of Section 192? The director has got to be acting in good faith in the interest of the company, and the judge has found that Mr. Singh in this period wasn't.
My lord, yes, I don't think that there's anything that I can say that is going to be able to rebut that position, insofar as we're concerning the factual finding that there has been a breach of the injunction, and that therefore amounts to a contempt.
But that is what your appeal is against.
Well, yeah, of course, yes. There are various different grounds directed to different elements of it, but I'm just doing my best to answer the direct question you've asked me, which is in this specific context. That there's a finding made here that there's the breach of the. I think the difficulty is the emphasis. The reason that it's. The reason relates to the finding that my client was in contempt, which is what the effect of 253 is. It's not the. I would quarrel to a much greater degree with any suggestion that the breach of the agreement in of itself amounted to.
No, that's not what the judge is saying. The judge's reason is that causing Genee to breach the injunction exposes it to fine, sequestration, and reputational damage. That's his point.
In 253, yes. Elsewhere, I think he does.
Yes.
Make a point
Well, he
there.
hasn't found your client liable for any other period, personally liable.
Yes.
So here, it's the added feature of the injunction and the possibility of fine, sequestration, and reputational damage, which has caused the judge to conclude, in a way I think you said you didn't quarrel with, that Mr. Singh was not acting in accordance with his duty under Section 172 to act in good faith in the interest of the company.
There is an additional point which I can make, which is, of course, that because he is the sole shareholder, there is a question about whether or not he can waive the breach in the circumstances. So, the duomatic principle.
Yes, if duomatic was going to be relied on, I would have expected it to have surfaced before now. Right.
The difficulty is, my lord, that insofar as 253 is concerned, the finding there is twofold, isn't it? That there's a factual finding about my client having breached the injunction.
Yeah.
And I've already said what I've said about my complaints on
Yes.
that. Of course, that isn't accepted, and I do challenge it within the scope of the arguments I've made in ground 2. So necessarily, it has to be read against that background.
253 doesn't say that your client breached the injunction.
Well, I think that the finding is, though, that in breaching the agreement, it's parasitic, isn't it? The breach of the agreement means that he must be in breach of the injunction.
No, the company is in breach, and the director, being the only director, is responsible.
Yes, but they're not. The distinction I'm trying to draw here is that whether the sales happened or not is a question of fact. That's already been determined by the judge.
Yes.
It then follows from that, his finding that they did happen, that was a breach of the injunction by the company,
That's not contested either.
and that is a contempt.
Yes.
And when I said the challenge that we make to that within the scope of ground 2 is, as I've said, and about the material that's available to the judge and
Yeah,
the comments that I've
we've
already
got
made,
that.
I won't repeat them. It is said elsewhere in the judgment that a breach of the obligations under the Companies Act would be automatically, if you like, an example of acting outside of one's authority and not acting bona fide. But I appreciate the question that was asked is that here that finding is being made. I don't think I can reasonably say that there is a scenario in which a breach of an injunction or a decision by a director to breach a court order could be excused in the manner that we're discussing. And I
Right.
think that's what you were asking, my lord,
Yes.
unless I misunderstood.
Yeah.
I'm grateful.
Right, so does that deal with ground 5?
My lord, yes.
Yeah,
I'm
right.
sorry, I'm just straining to look at the clock to see how much more
5
time
to
there is
12
before the
it is
lunch
now.
break. Because I have ground 5 to deal with and I've been handed a number of cards by my
Well,
client.
I thought that was ground 5.
I apologise, ground 6.
Ground
So
6.
there's the damages ground, which is a separate.
What I understood you to do was you started on ground 4 and then the discussion moved on to ground
Yes.
5, so you really dealt with both of them together.
Yes, and I haven't, and I don't think there's anything further that I can add to those, which is going to assist your lordships in determining
Yes.
that ground. So the final ground that I have to deal with is our damages ground. And I'll try to put this one quickly because it's perhaps of less significance in the sense that it relates only to quantum. I want to be clear about what I'm suggesting in this ground. I don't dispute that the experts went away and formulated a figure which they said represented 5% of the, that they went away and did a report on what the profits would have been arising from the disputed sales. So I don't dispute that the experts looked at that question. The reason that I dispute the approach of the judge is that it seems to be that throughout the process and throughout the judgment, the word loss and his conception of loss is simply elided with whatever the profits would have been had the sales been made in accordance with the agreement. And the basis for my complaint on this is that looking at paragraph 340, the learned judge says this: Northamber's recoverable loss is therefore £24,567 brackets, that is 5% of £491,000 on the basis that Genee would have charged Northamber what it charged IES. So it is essentially taking the profit that would have been earned on the one hand and handing that over to Northamber. And that is described by the judge as the recoverable loss. And it seems to me that prior to this, it was just described on that basis and argued on that basis. The complaint I have about that is that that, of course, is not the actual loss that flows in any sense from the breach that has been demonstrated of the exclusivity agreement. Now, I recognise that when one is considering obligations of this nature, so restrictive covenants or covenants in an exclusivity agreement, very often there won't be direct consequential loss in the sense that the breach of the obligations doesn't give rise to losses that can be ordinarily compensated. But that doesn't mean that the proper approach is then to simply take and disgorge the profits which have been earned, if you like, in breach of the covenant, and provide them and or hand them over to the alleged victim of the breach of contract.
I'm sure it's my fault, but I'm not following the point you're making, because what the judge does, he says if there had been exclusivity as the agreement provided, then the sales would have gone through Northamber. The price would have been the 491 figure, and Northamber would have added its 5% margin, and therefore that's what they've lost. Why is that not lost to Northamber?
Because in my understanding, my lord, that isn't what Northamber, those aren't funds that Northamber would otherwise have had, because
Why not?
we were alleging as a matter of fact that the sales would never have taken place, or that's the factual case that was put by my client.
But here we've got Genee with product to sell and somebody who wants to buy it, and the exclusivity agreement says it must go through Northamber.
Yes.
You didn't. So the object of damages for breach of contract would be to put Northamber in the position it would have been in had the contract been performed. If the contract had been performed, the sales would have been routed through Northamber, who would have made a profit of 5%. And on one view, that's rather generous to your client, because clause 9.2 of the Exclusivity Agreement says that breach of this exclusivity of supply agreement will result in Genee compensating Northamber with 25% of the lost revenue. In fact, the judge has only done 5%.
And the judge explains why he does that at 336.
Yeah.
Thank you, Lord. I'm just considering that point, and then I will consider our response before moving on to my responses to the.
And what he says is that the claim is in tort.
So, my lords, I think I can put it no higher than this. The complaint, there's two points that are raised, and perhaps one falls away if as I suspect, the position is different. There is what we say a failure to analyse factually what would have happened but for the breach, and we say that the sales would not have taken place at all, and that was caused by client's position at trial. So factually, that loss didn't arise.
But the judge held that they would.
Well, I'm planning on, I think, concluding my submissions, and I may take a view on this ground in particular. But before I do that, can I very briefly turn my back just to
Yes, but briefly.
Yeah, sorry. Sorry?
My lord, can I say I'm not going to proceed with this ground? So can we move on that basis that I put forward, of course, the appeal on the grounds of 2 through 4.
Yep.
And I don't have anything further to say in relation to 5, but I'll consider that not pursued. So that brings me very briefly, and it will be more brief because I have a lot left to say, a lot of the material having been covered by my learned friend, on the response to my learned friend's appeal. I don't have anything to add to my learned friend's analysis and the analysis that he has given in respect of the questions about inducement, and of course a lot of that directly relates to First Defendant specifically. I'm going to start my analysis and my response in relation to my learned friend's ground 3, which is a criticism of the way that the judge at first instance approaches the assessment of my client's alleged lack of good faith. So the grounds put on the basis that there's a failure to consider globally, e.g. from the 1st of July 17 through to...
Just before you embark on this, may I inquire, why do we not have a skeleton argument containing your response to the appellant's appeal?
There was nothing specific that we had to add in response.
I mean, normally, if you're going to say anything about it, this court would expect a skeleton argument on why you dispute the appellant's grounds, but we've got nothing.
Yes, my lord. I do plan to keep my comments very limited, and
I think you'd better.
if I can put it this way, my lord, there is nothing substantive that I'm adding to what my learned friend has said. The responses I want to make are confined to points that were developed orally during the submission, so perhaps if I can put it that way.
But standing back, I mean, ground 1 doesn't affect your client. Ground 2 does affect your client. So far as the unlawful means conspiracy is alleged to have included him, so you do have potentially something to say on that. But ground 3, which is what you were about to say something about, you've actually already covered, because this is all about the Saeed and Buck point, and
Well, yes.
you've already addressed us on that.
I mean, yes, that's correct. I will only add this then in that case, because as I say, it's not my desire to introduce new argument at all. And that's why there's not a specific skeleton, because there isn't anything specific to add. But I think the point that I would make in response to the way that this was developed in submissions was that what's actually really being said in relation to the failure to consider globally is essentially that I think it was conceded that the 3 conclusions that were reached in relation to the 3 periods, as explained by the skeleton argument on paragraph 44, that those were not subject to criticism, that the individual assessment of each period were not, if you like, impugnable.
But on periods 1 and 2, this is where your point that it wasn't put to your client in cross-examination has particular force.
Yes.
And I think we've got that voice already.
Yes. I think I'll just add this then. It seems to me that what you were being invited to do was hold that rather than undertaking, if you like, a more forensic analysis of the position between each individual period, that there should have been an additional step where the judge took a step back and essentially generally looked at whether or not my client was acting in good faith. And I would submit that, first of all, that's not an approach which is supported in any way by the authorities you were taken to. But second of all, clearly wrong in my view, and is, if you like, an appeal to a sort of argument that the judge should take a palm tree view of the overall position as opposed to looking in the granular detail. But as my Lord Justice Arnold says, that there's been a great deal of argument on this, and then perhaps I'll move on to the 4th and 5th grounds. I don't have anything to add on the 4th ground because the points were taken, I think, by your lordships as to the construction. Other than to say we agree that it's a matter that's clearly within the discretion of clearly within the gift of the trial judge to determine in the way that he did.
Well, say gift. I mean, either he's right. It's a question of law what this agreement means. Either he's right or he's wrong.
Yes, my lord. In relation to the 5th ground and the arguments about the cost order, again, I don't have anything specific to add other than the points that my learned friend took. Other than, I suppose, to respond to what my learned friend leading counsel said, a number of times it was put on the basis that the judge didn't have regard or didn't take into account the role of mediation, and that's, I would say, plainly not accurate. He did take it into account because he considered its relevance, and he considered the offer that was made and its bona fides, if I can put it that way. and he's clearly entitled to do that in my submission, he's clearly entitled to take a view that an offer of mediation is not a credible one or not one that's made in good faith. And the reasons he gives for it are perfectly rational. He explains that it's at a very late stage of the appeal. But the reason the ground should be refused is because in my submission it does amount to asking the court to conclude, essentially, that where there's a refusal to participate in mediation, the judge must reflect that, not just in the reasoning, but it must sound in their decision, and I think that has to be wrong.
There wasn't a refusal to engage in mediation, was there?
I'm sorry, no.
There wasn't a refusal, was there?
Well, there wasn't a response put to the original letter,
Yeah.
so no, it'd be
There
wrong.
was silence, and the silence was in breach of the court order.
Yes, my lord.
And you say that breach should have no consequences at all.
It's not that it should have no consequences at all, it's that the judge heard detailed argument on why it should because we have to also bear in mind, my lord, where Malone and Friends clients were coming from at this time. And this goes back to what Malone and Friends This goes back to what my lord, Lord Phillips, said yesterday about the sense of reality, is that they weren't asking for this to sound in the assessment of costs having succeeded. They were asking it to sound having failed almost entirely in relation to my client and entirely in relation to D3. So it's not that it has no relevance.
Yeah.
Well, I don't think I have anything to add on that. Unless there's anything I can assist you with further, those are my submissions for now.
Thank you, Mr.
I'm
Ingham.
grateful, my lord.
My lord,
Mr.
shall I-
Cockle, do you wish to reply?
I'm sorry, my lord.
Do you wish to reply?
Just a few very quick points, not on the majority of the matters that have been raised, but first to answer various points on Northamber's two applications, that's the ground 6, ground 7. Then to reply to Mr. Budworth's submissions on our grounds of appeal. In fact, it's only on the first ground that I have anything particular to say. The rest is already within my submissions, oral and written, and then a very short reply to Mr. Ingham's appeal grounds. I've handed up an extract from Clark and Lindsell dealing with justification in the context of using breach of contract, I think. I've also handed up a copy of the Outer House judgment of Lord Hodge in Global Resources, and your lordships will remember that that is
Yes.
referred to in Clark and Lindsell, and it's also referred to in the Kawasaki judgment. And if I may respectfully say so, it does bear reading. It's a very clear, crisp analysis, which is particularly relevant here. And then there's another House of Lords case, which I'll get to when I answer Budworth's proposition of British industrial products, but I can introduce that then. So first of all, my ground 6, and it's said that the court shouldn't entertain it, it's academic. Well, I've said what I said in relation to that. I think Mr. Ingham recognised this morning that it impinged on the conduct of the second defendant in his case, because his conduct was being called into question as an office holder. But in any event, if the slip ground is entertained, is there any good answer to it? And we say there isn't.
Well, sorry, I haven't understood what your answer is to the point that it's academic.
Well, yes, my lord, it is academic. But we don't read academia in a pejorative sense.
No.
Sometimes it isn't necessarily pejorative.
But there are well-known constraints upon appeals on issues that are academic. I mean, the pop dog criteria are not satisfied, are they?
Well, we think they are because it is, in fact,
But how can they be? How can they possibly be satisfied? One of the criteria in Pop Dog is that both sides want the court to determine the appeal, and your application is resisted.
Well, the only other point that I'd make, and it's as a side comment, your lordship suggested CPR 3.1 subpara 7.
Yes.
but there's a recent authority from a very eminent Court of Appeal judge last year suggesting
That's
that
you
this-
and me, Kim.
suggesting that it's not appropriate to revisit final orders.
No, indeed.
So perhaps we can move on then. I've said enough in relation to that particular application. In relation to ground 7, yes, we're out of time. In fact, for an amendment of an appeal ground, it's 52.17 in the CPR dealing with appeal grounds. And your lordships will know when you last had an opportunity to be given a copy of the White Book that there's very little text in
No,
there.
they say refer to Part 17, and Part 17 is all about amendments at trial. So
It
I
is.
don't think you really get very much out of reading it.
No, and there's also something in Practice Direction 52C, I think
Yeah,
paragraph
but that doesn't
30.
tell you very much either.
That doesn't tell you very much, but there certainly have been episodes, if I can put it that way, where the Supreme Court and the House of Lords have allowed amendments at that stage.
Yes, I think it's not impossible, but the point here is that if you wanted to open up a factual finding by the judge, your opponents needed to have time to consider what the response might be, because, I mean, if your ground 7 remains as drafted, and we simply say, well, the judge didn't deal with it, so what? He didn't deal with it. If you say he should have made a different finding, or he should have made a finding in your favour, then it's not fair, it seems to me,
No.
to your opponents to say that on the hoof, they've got to go through all the factual material. There might have been respondents' notices and saying the judge didn't take this piece of evidence into account or that piece and so on.
Don't quarrel with any of that. The way that I deal with it is I say that it's going to be dependent on what happens to my ground 2, my conspiracy claim. If and only if that is successful, then I need this in
Oh, I
order
see.
to. So if I'm successful on ground 2, it needs to go back to the trial judge anyway. And so what I would be saying is that if
Well, wait a minute, why? If you're successful on ground 2, why does it need to go back to the judge in the absence of a finding of combination?
Well, slightly chicken and egg. What we say is if I'm successful on ground 2 about our conspiracy claim,
Yeah.
then that calls into question the judge's conclusion in relation to unlawful means conspiracy. There is an issue that falls to be redetermined in accordance with
Yeah.
findings of this court. So at that point, the matter needs to be re-evaluated, whether by the judge below or to a new judge, whatever your lordships decide, and indeed whatever is practical. And at that point, we say, should be considered also the other elements of conspiracy. So there is the
Can you
opportunity.
explain the logic of that to me? Because at the moment I'm struggling. Because what your ground 2 says is, on the points that the judge decided adversely to you, he was wrong. And if we're with you, we will so decide. But that then leaves open the problem that there were other elements of the tort that he simply didn't decide, because on his view of the case, it wasn't necessary to do so, because he'd rejected you for the reasons that your claim for the reasons that he gave. But doesn't that highlight the point of my Lord's question? Because what you're then into is a scenario where, yes, you show he was wrong to dismiss it for the reasons he gave, but then you have the points that weren't decided. And it's open, would have been open to your clients to say, he should have decided those points. But then that instantly leads to the question of, well, what then is the proper remedy? Is it a rehearing, a retrial of those issues? Or is this court in a position to decide it for itself?
And the answer, my lord, is not the latter, in order to address the fairness point. That's the point. Not the latter. I don't ask for the latter in relation to my proposed ground 7. And that's how I deal with the fairness point.
Yeah.
So those all that I wanted to say further in relation to the two applications. I turn then to Mr.
Sorry, just before you go on, I think in answer to my Lord Justice Arnold, you accepted that ground 6 is academic. But you still persist in that application, do you?
Well, gently.
Gently, right.
Gingerly. My Lord, I turn then to Mr. Budworth's submissions, and as I said, it's really only my first ground. That's the misstatement of the requirements of the elements of inducing a breach contract. And first point I say in reply is the mistake that Mr. Budworth makes, and indeed which the judge made, is not to treat each breach of the exclusivity agreement separately.
Yeah.
And so if each purchase order, regardless from whom, results in D1 breaching the exclusivity agreement, then each person who submits such an order, knowing of the exclusivity agreement, is capable of inducing the breach of contract. And the fact that the first defendant has a proclivity to accept such orders doesn't diminish, in a sense, the position of the person inducing. In fact, if it's known, it makes it worse that you're going to a person who has a history. So
But I suppose you would say that, you know, even if a stranger, so to speak, made an offer to Genee, which Genee accepted, that would be inducing breach of contract, but it wouldn't be a tortious liability because they didn't know.
exactly. So that's the knowledge, and I've always said that knowledge is the controlling aspect of the tort itself. Secondly, yesterday the submission was made that the purchase order to Genee was not sufficient to constitute the tort, just the making of it. There had to be some further act or activity.
Well, as my lord pointed out, they didn't just place an order, they took the goods and paid for them.
Well, exactly. But in any event, one of the authorities that I handed up this morning, the House of Lords Authority, which was concerned principally, it is correct, with the element of intention, but there are factual parallels with it insofar as it was an offer that was made, which was accepted, and that was all that was done. And your lordships will see in the speech of Lord Russell at 481 letter B, 481 letter B, the judge found that all but one of the essential ingredients of the cause of action had been proved, and what hadn't been proved was knowledge on the part of the respondents. So the judge there, and there's no criticism of that, and it's quite a line-up, both of judges and indeed counsel. No issue was taken with the fact that if the defendant has essentially placed an order with the party, with the contract, that will do, and nothing further is required. So it's an illustration that is sufficient, but as Lord Justice Arnold has pointed out, there's rather more than that in the present case. That also answers the point that was made by Mr. Budworth yesterday, that this court should not accept Salvadori, because the British Industrial Plastics case is on this point at one of Salvadori, which came a few years later than that. Next point that I make in relation to Mr. Budworth's submission is justification, and I handed up the extract from Clark and Lindsell, which is there. I don't know that it helps the court all that much, other than you have it. And the justification defence was considered at paragraph 327 of the judgment, and the answer to it was given at paragraph 300 of the judgment. And I'm sorry, my reference is wrong there.
302 and 303.
Yes, 302, 303, I'm grateful. And that is a correct analysis. The cases show that where justification defence exists is where there's some, for example, statutory obligation on the party, the defendant party, to act, or it's to prevent something fundamentally immoral taking place, as another example the courts have given, or if it's going to frustrate another pre-existing contract in a way. And that's the starting point, because always the court will evaluate the competing considerations. But mere bettering of the defendant's economic interests with no more cannot provide justification if the breach of contract so induced is not and cannot be to the advantage of the claimant. And there is no, which is essentially what Mr. Budworth was submitting, and there's no authority to support him in making that submission. In relation to the LGF credit facility, Northamber was not responsible for that and for making it more difficult. And the position in relation to the Lloyds Bank Commercial Finance was considered, or spoken to, I should say, by Mr. Henry in his witness statement that was before the judge, and your lordships have that in supplementary bundle, tab 8, page 503.
Supplementary bundle.
Tab 8, page 503. Well, it starts earlier on. It starts at page 485. Relevant
Yeah.
paragraphs of 59 to 68. There's a long explanation. And I don't want to go into the detail of this particularly, as it seems to me that what the court was being drawn into was a redetermination of matters of the hearing itself rather than of the appeal grounds. But
Was it particularly paragraph 60 to do so?
yes, well, yes, it's particularly paragraph 60, and in the 64. The other point that is relevant to Mr. Budworth's submission is clause 6.2 of the Exclusivity Agreement, which starts at page 262 of the agreement, but clause 6.2 is at the top of page 264, where Genee gave Northamber the right to deduct from any payment to Genee an amount equivalent to any overdue monies owed by Interactive Education and D3 to Northamber.
Yeah.
If Interactive was more than 7 working days late in paying an invoice to Northamber. And that was the contractual backdrop.
Right.
And the judge, in a sense, was on to this and spoke to it at paragraphs 80 to 83 of his judgment, which is in the core bundle at page 144.
Yes.
So there isn't a point, there isn't a justification point that's available for the third defendant, and that's all that I wish to say in relation to that. In relation to Mr. Budworth's submissions on ground 2 conspiracy, there's nothing further that I wish to say. Ground 3 didn't concern Mr. Budworth, and his submissions in ground 4, that's the interpretation of exclusivity, faded away, and I don't have anything to say in relation to that. And so to his submissions this morning in relation to costs. So I can turn then very briefly to Mr. Ingham's submissions to this report today, in particular round 2 of his appeal, and where he claims that it wasn't open for the judge to find that D2 had acted outside the scope of his authority. And this overlaps with our ground 3, of course. And the short of it, my lords, in terms of so-called procedural fairness, is the point that I made before, that paragraph 29 of the judgment, that's page 130, the judge identified the 9 issues which all counsel agreed had to be determined by him. And
Yes, you say it was one of the agreed issues.
yeah, so fairly and squarely, that was before him. And
If you have an agreed issue, but then you don't cross-examine on that issue, that makes it worse, doesn't it? Because it shows you've decided not to pursue it.
well, no, it wasn't that it wasn't. Yes, it does worsen. I can't disagree with that. It does, but the question always is, and when your lordship says to me that worsens it, did they have it fairly before them? It's a matter of fairness, and that, of course, is one of the functions, not the only function, but one of the functions of a statement of case is to put the other side on notice, and then, of course, to identify the issue for the court to decide. It wasn't in the pleading, but all the parties agreed that it was an issue there to be decided. And indeed, of course, the judge just dealt with it as a discrete issue.
Well, can I put the same question a slightly different way? So, Dewey and Griffiths says the general rule is you must cross-examine, but it acknowledges that that's not an absolute rule. There are a number of exceptions to that general rule are identified. Are there any of those exceptions that you say are relevant here?
Well, I've always understood the rule to be the rule in Brown and Dunn, which,
Yes.
and when you look at Brown and Dunn, eventually find it in one of those obscure reports, it is founded in fairness to the witness and fairness to the party.
Well, the rule in Brown and Dunn, and as explained in Dewey and Griffiths and so forth, is that it has to be fair to the witness to answer an allegation that his evidence is disputed. That must apply even more so in a case where you wish to say that a witness has been dishonest or has acted in bad faith.
Yes, and
Rather than simply saying you've misremembered or you've got it wrong.
No.
Or whatever.
and certainly it must be put to a witness. I say must. So there's no discretionary element that if a witness has been dishonest, it must be put to the witness so that the witness can answer it. And there's always been my understanding you can't even make a submission at the end unless it has been put to the witness. That's just university stuff.
Understanding too.
But the question then is, no, well, I can't get around that. I mean, I'm not going to argue for the proposition that's been known to me for 40 years, so I'm not going to erase that for my legal knowledge. But what I say is, it isn't all one way, because the judge specifically said and recorded in his judgment there was an opportunity for Mr. Brown then to take issue with it, but he didn't take issue with it. And the question then is, given that tension between the two,
Yeah, that's a bit problematic though, isn't it? Because on the one hand, as you say, Mr. Brown didn't pursue his application to strike out, which would have been a rather odd application anyway. And on the other hand, Mr. Falkowski didn't insist that the judge grant him permission to make the amendment and then amend.
I know.
So it's just a bit of a procedural muddle at that point. But I mean, I take your point that it was one of the agreed issues.
And the other thing that Mr. Ingham conjectured this morning was that had the point been properly pleaded, then the trial might have proceeded in a different way. But he wasn't able to identify how it would have been different. And indeed, in the second defendant's trial skeleton, the point was dealt with. And your lordships have that in the supplementary bundle. Tab 10, page 585. So the paragraphs, it's paragraph 7 and 7F for Freddie, 585. So there's the issue.
F, yes.
And then it's dealt with later on, paragraphs 46 down to 58, albeit he takes the point that there's a pleading difficulty, which only underscores the puzzle why he didn't hammer home the point when the invitation was put to him by Judge Below. There it is. It is ultimately, I say.
I beg your pardon, could you give me the paragraph reference again?
The first one was 7F.
Yeah, I got that.
And then the other paragraphs start at page 593, paragraph 46, concluding at 58.
Yeah, paragraph is really, the pleading point's taken at paragraph 58.
Yes, I think it's also taken earlier on. There's also a reference earlier on. In footnote 9.
Yeah, but I think the point, and again, one needs to separate out the pleading point from the lack of cross-examination point. But so far as the pleading point is concerned, as I understand it, what you do is I mean, we can see it by reference to footnote 12. Any attempt by C to rectify this by late amendment will not be objected to. Well, it wasn't rectified by a late amendment, but equally, Mr. Brown didn't obtain a ruling from the judge that it was put up or shut up. In other words, barring your client, Northamber, from advancing this claim against Mr. Singh without pleading it. And Hawksworth tells us that having failed to do that, it's now too late to take the point. And that, at the moment, seems to me to be an answer to the pleading point, particularly given, as Muddle points out, and as you demonstrated, it was an agreed issue. But how is that an answer to the absence of cross-examination?
The Brown and Dunn point, I think, is a higher hill to climb, or rather one's a mountain and the other's just a...
Right.
So that's all that I wish to say in relation to Mr. Ingham's ground 2. Ground 3, I think I can probably deal with lightly. That is that this is a collateral attack on the judgment of Judge Ashworth. We've dealt with this in a skeleton. The point's misguided. Contempt has to be proved to a criminal standard, not a civil standard. That's the first problem. So you can, even if there were identity of issue, which there isn't, I'll get to that in a second, even if there were identity of issue.
But Mr. Ashworth, as Lord Justice Arnold pointed out, Mr. Ashworth decided different orders.
Yes. So there's two things.
So
Even if there had been an identity of orders,
well, they weren't. So you don't need to address that.
And Mr. Ingham realistically accepted that in the course of his submissions.
I'll go on to issues 4 and 5, the bold submission about Saeed and Butt. And it just doesn't bear analysis with the authorities. There's the judgment of Mrs. Justice Gloucester, which the court has seen. And it's also the conclusion that was reached by the judge below is consistent with the Antuis judgment that's referred to in paragraphs 226 of the judgment, page 182. There's a long extract at 225, excuse me. Because that was founded on a breach of sections 172 and 174.
So the submission was made that that was wrong.
As I understood the submission as it ultimately came out was not every breach of 172 will be sufficient, but some breaches can.
No. Not every breach of the Companies Act will be sufficient.
Yes, well, I think we can probably agree on that. But the question is, 172, section 172 embodies within it an acting in good faith for the company.
Sorry to interrupt you, Mr. Cobble. What the judge said at paragraph 227D is Mr. Singh will not be acting bona fide if he acts in breach of his duties under the 2006 Act, including 172 and 174. And what I think is being said was, well, that's too wide. It's not every breach of duty under the Companies Act which will get round the rule inside and butt.
But when one goes on to
But the judge's factual finding is that there was a breach of section 172.
So he confined himself to 172,
Yes.
and he did so in a way which explained why it was.
Indeed.
And that's the answer to that. So to latch on to some general statement doesn't take my learned friend anywhere in relation to grounds 4 and 5. Ground 6 was abandoned, and then in Mr. Ingham's submissions on my grounds, I don't have anything to say in reply.
Yeah. Right. Thank you. Thank you, Mr. Coppell. Mr. Budworth, I think strictly speaking, you are, if you wish to, entitled to reply on British Industrial Plastics and Ferguson. Mr. Ingham, do you wish to reply on British Industrial Plastics and Ferguson?
Lord, no, I don't. I did very briefly want to just address you on, I suppose there's a bit of a hangover position of this unagreed bundle and the extent to which you...
Well, we've said that we would consider it if it proves necessary. We haven't been specifically referred to much, if any, of it, apart from Mr. Ashworth's judgment, which we've got. Thank you very much. So I think we'll leave that where it is.
What I would say, just...
So this is not a general invitation to reply to a reply.
I understand that, my lord, and I apologise if I'm overstepping the mark. My client wanted to instruct me to make reference to specifics, but if that stretches beyond what you're inviting me to do, then I won't.
I think it does.
Obey you.
I'm afraid it does.
I'm grateful.
Right, well, thank you all very much for your arguments. It will not surprise you to learn that we will reserve our judgment. The judgment will deal with the two applications that the appellant has made, one I think gently, the other not quite so gently, and they will be dealt with in the judgment. You will in due course get draft judgments. It will be your opportunity to point out any errors in our English, but not our reasoning. The draft judgment will come with an embargo, which means that you cannot distribute it except to those on the distribution list. And once we have received your corrections, if any, and your proposals for a draft order, which we hope you will be able to agree, the judgment will be handed down remotely, electronically, and there will be no need for any further attendance. Thank you all very much.
All right.